This podcast is intended for informational purposes only and should not be considered or interpreted as legal or professional advice.
Welcome to episode 2 of Mika Minutes. I'm your host, Mika Domingo. How do you become a conservator? If you have aging parents, you may be seeing signs of decline which you can't ignore. When your parents reach a point when they are no longer able to manage their affairs, it may be time to petition the court for a conservatorship. The standard for a conservatorship is high because once a conservatorship is in place, an individual's rights are taken away. A conservatorship is when a judge appoints another person, a conservator, to act or make decisions for a person, a conservatee, who needs help. This may happen when someone needs assistance with managing their own affairs due to their age, their physical or mental illness, or because they have become incapacitated. In this episode, we will be discussing general conservatorships, which are the most common category of conservatorships. In California, there are 2 types of conservatorship. The first is conservatorship of the person, which gives the conservator the right to make healthcare decisions for the person. This includes deciding where the person will live, what medical procedures she should have, and other important decisions regarding her physical body. The second type is conservatorship of the estate, which gives the conservator all the responsibilities of managing the person's finances. This includes purchasing and selling real property, managing bank accounts, paying bills, etc. In most cases, a conservator of a person with dementia will assume all of these responsibilities. Who can become a conservator? People who are qualified to be appointed as a conservator include a spouse, an adult child, a parent, a sibling, a person the court approves, or a public guardian. There are multiple forms a potential conservator will need to complete, including a petition for appointment of probate conservator, the notice of hearing, confidential supplemental information, citation for conservatorship, duties of conservator, confidential conservator screening form, order appointing conservator, and letters of conservatorship. Some courts require more forms to be filled out. Potential conservators should take their time in gathering the correct information needed to complete these forms. Once these forms are completed, they are ready to be filed. The court will stamp the notice of hearing form, which will state the date and time of your conservatorship appointment hearing. When the hearing date and time have been acquired, potential conservators must give notice that they are petitioning to be appointed as conservator of another person to certain people involved in your loved one's estate. It is important to strictly follow all the rules your court gives you for providing notice. Potential conservators can also call their local court to see if there is anything else that needs to be done prior to the hearing date, such as taking the classes for non-professional conservators. And it's usually available through your local library or sometimes even online. And make sure you still involve your loved one in the decision-making processes. Until their legal capacity to make decisions is determined, it is important to honor your loved one's wishes when handling their personal care and finances. If you are directly involved in your loved one's conservatorship case, and if they are still able to communicate with you, be sure to talk with them and allow them to be involved as much as they can during all the steps of establishing their conservatorship. Sometimes they simply are not able to communicate. In that case, you will handle and the court will provide you with an opportunity once you're appointed to then manage your loved one's care. In my next episode of Mika Minutes, we will discuss the responsibilities of being a conservator.